Council, and Daryl Hall. Hale, thank you.
You call it worse.
Worse, okay, well, I'll try to do better.
Nice, sir.
Thank you. Let the records reflect the members that are here this evening. Commission members should have received the minutes of June the 21st, 2020. Is there any corrections or additions to those minutes? Hearing none, I'll entertain a motion for approval.
So move.
Second.
Okay, motion made by Ollie, second by Jim. Any further discussion? All in favor of approval, signify by saying aye.
Aye.
Those opposed, nay. Carried, thank you. Delegation and action items for tonight. We have development rights and responsibility agreement for the village at Mead Crossing, amendment to enable placement of sheds on single-family detached lots. And then the second part of that is certification of a consistency with the Taneytown Comprehensive Plan. Jim, if you would like to lead us off on that?
Sure. So just to set up the general idea here, in a community village, typically individual storage buildings are not allowed. In community village, there's an option to do a centralized storage area for the community. And in this case, Meads Crossing opted not to provide a central storage facility. And over time, I suppose the idea of not having individual sheds was forgotten, and a number of property owners have expressed interest in having individual sheds in their yards. And Mayor and Council have debated the issue and come to the decision that it would be okay for the single-family homes to have sheds in the yards, but limiting it so that townhomes would not. I believe the logic in that is lawn maintenance at the townhomes is the lawns are mowed by the association, whereas the single families, the property owners are responsible for maintaining their own lawns. So they will need some kind of lawn care equipment. All that said, the DARA was the best way to, since we already had an existing DARA for Meads Crossing, we felt like the best way to facilitate the sheds was to speak to that in the DARA to enable the sheds on single-family lots. So it does also take, and I'll kind of tie the two together here, it also will take a zoning ordinance amendment so that it provides some enabling language, basically, that says that the individual storage sheds are prohibited unless otherwise specified by a development rights and responsibilities agreement, or DARA as we call them. So all that said, the commission's role is really just for the development rights and responsibilities amendment, is just to ensure that it's consistent with the Taneytown Comprehensive Plan, which in this case, it's still, the land use is the same, it's still, still residential development, still the same density, so really nothing in terms of comprehensive plan goals and objectives is changing from it. But the process requires you guys to certify that. So that's, I was going to say in a nutshell, maybe it's a little larger of a nutshell than I was planning, but that's basically it.
So we're handling this on a case-by-case basis, right? So this only affects this development site, right?
Correct.
Carol Vista or any of the other, they would have, right?
Correct. So first off, for this to happen in another community village, that community village would have to have a development rights and responsibilities agreement, or they don't have the vehicle through which they can make the change. So they would need to have we abbreviate it as a DARA to begin with, and then again, case by case, it would be up to the mayor and council to decide if that was something they wanted to enable for that particular project. And I think if we, have the discussion, and again, with Meads Crossing, remember, they were approved right before the real estate market tanked. So there was a long period of downtime between the original approval and houses, being on the ground. And there was talks with, throughout that, there were talks with different builders. And so a lot changed between the original approval and a lot of time lapsed between that and when the houses were actually on the market for sale. So, there were some out of the ordinary circumstances with Meads Crossing, I think that, and that time lapse certainly didn't help the idea of sheds stay on the forefront of anyone's memory.
So what period in time was the central storage area eliminated from the plans? Because I don't recall it coming back before us, or did it?
Well, there was never a central storage facility on the plans, but one of the comments many, many years ago, probably back, I think the original plan was approved in maybe 2010 or 11. So it was one of the comments leading up to that was, community village prohibits sheds. If you're going to have a central storage area, please show where it's going to be. And the response was that there wasn't going to be a central storage area. And that was before there were a lot of other amendments to the plan after the real estate market plummeted and then started to come back. So there was never a central storage area proposed.
And they're requesting the storage for lawnmowers? Is that why the main
For
reason
lawn
for
care
it?
equipment primarily.
If I can give you some other background, because this isn't the ideal way to deal with this. It's the best way with the circumstance we have, but ideally, the community village ordinance would have been written to include sheds from the get-go, or an approval process, or something, not just a strict ban. But that ordinance was written for Carol Vista. Okay, the Carol Vista attorney, prior to me, wrote it for the town, and Carol Vista is a condominium. So they don't own anything outside their house. So there's no lots for them to put sheds on or anything like that. So it wasn't necessary, so they could just say it's prohibited, easy. And the structure at Meads Crossing is obviously individual lots. They own those lots, they have yards, and their homeowners' docs allow them, and they have to get approval from the homeowners for, architectural stuff like that. But our ordinance wasn't designed for that. So the theory was, how can we solve this problem today without creating other problems from the past or in the future? And since Carol Vista doesn't have a developer anymore, it's all built out, they'd never be able to get a DARA with us. So we don't have to worry about that. It wouldn't mess anything up. And any new project that comes in, we would be able to say yes or no, or how we want to deal with it in a DARA. And so that's why the hook is in your ordinance 02-2021. There's only one little line in there that says unless approved by a DARA. So it should give us more flexibility than less, because you'd be able to deal with it on a case-by-case basis. However, I'm not sure that the mayor and council really want to keep the community village ordinance the way it is for new projects, for the projects you never heard of type of thing. They're talking about revamping it all, and this could be part of what revamping it would be. So.
Why not include the townhouses? Why shouldn't, I'm just wondering why, if we're looking to future-proof it, obviously somebody with a townhouse is eventually going to complain that they don't have sheds, but the people around them are allowed to have sheds.
I think it
Is
was
there a
the
specific
maintenance.
reason why they can't? The maintenance, yeah, they get the maintenance care provided to them, but
Right.
I don't see why in particular that would restrict them from having the sheds while everybody else does have the sheds.
I think the developers can answer that, but don't think of it like they don't need a lawnmower, so they don't need a lawnmower, so they don't need a shed.
Yeah,
It's
that's-
more of the company, that since the association maintains all the outside area, we don't want to have sheds just thrown up because it messes up how we maintain things. So, and there's also, of course, we didn't look at it for townhouses, but one of the requirements is that they have to meet all the other zoning requirements. So there's still setbacks, offsets, and things like that that have to be met. And those townhouse lots are long and narrow. So it's going to be difficult. Again, we didn't look at that, to try to get a shed of that size to meet the side yard setbacks from everything.
And just one more note on that. The ordinance is the one that's going to govern going forward for projects beyond Meads Crossing. So if there's another community village that has townhomes or, you know, triplexes or quadruplexes or something like that in addition to single families, and the question of sheds arise, that would be up to the development rights and responsibilities agreement for that particular project. So the ordinance doesn't eliminate the possibility going forward for townhomes to have them. It's just the DARA that's going to apply specifically to Meads Crossing stops them from happening in Meads Crossing townhomes.
We should look beyond not just lawnmowers, because I'm sure a family dwelling is going to have summer equipment, lawn chairs, the grill, and all the other things you'll have to store somewhere. So it's more.
They can't have fences either at the townhouses, right?
Correct.
Am I right on that?
Yes.
They can't have fences.
The townhouses are smaller than the regular houses, are they not?
Yes.
Mhm.
And that
So-
said, they all do have garages, at least a single car garage for, you know, for some modest level of storage.
I mean, not to throw like a wrench into it, but I will say if I was in a townhouse and, you know, again, I saw other people with the other houses getting sheds and stuff like that, I could see where somebody is eventually going to come back and say they want a shed, all these other houses are getting sheds, but I can't have a shed because I'm in a townhouse. And a smaller house, you're going to need, probably a smaller family is going to be in the house, but you're still going to want that storage space that other people are going to be allowed to get from something like this. I mean, I'm not sure how all y'all feel, but again, if I had a townhouse and I saw everybody around me getting townhouses, I would not be too pleased. Or if I had a townhouse and didn't have a shed and I saw everybody else getting sheds, I'd probably be a little irked by the idea that they're allowed to have it, but I'm restricted by the same policy that they went ahead and changed.
I think Mr. Smith might give you, I think one of the things, the townhouse covenants may be different and may be prohibitive.
Yeah, I mean, I'm not
From
familiar.
their-
I'm not
their
familiar with
situation.
townhouses, so.
Yeah.
All
So,
right.
hi, I'm Steve Smith with Meads Crossing, and also I've got Ed Gold, my partner in it. So you bring up a good point. It is very clear in the bylaws that the townhouses sheds are not allowed. And so I think we haven't gotten that feedback, but that's not to say that if we did, maybe we would come back and ask for something that perhaps is up against the back wall of the house. It can't be, it really doesn't make sense for it to be a freestanding structure because we are providing all the mowing around and just from the efficiency of having to work around those things. But at this point, we just haven't gotten the requests. So.
Okay. And I mean, I know one of the things we were talking about just a little bit ago was when we're coming back with this stuff where I know they want to make sure that it's future-proof and we're not going to come back to the same issue. I mean, to me, this isn't future-proof in that eventually the problem is going to arise again and we're going to have to go through this whole step again. But I mean, I'm fine with it. I'm just, if I had a townhouse, I'd be a little irked.
Well,
Being disallowed
and
to have a shed.
from our standpoint, if you all decided that you wanted to allow them for townhouses, we would probably not raise our hand and announce that. I know we wouldn't. But if there was enough interest down the road, then perhaps we would allow some form, but just not as a freestanding structure.
Addressing the people that's already moved there, and I don't want a storage shed in my backyard or be able to look out my backyard and see one in the neighbor's yard. How are you addressing that with the people that's
Well,
already purchased their homes?
So there's another side to this that is our problem, in that when the HOA documents were written, they don't prohibit sheds. In fact, they say sheds can be allowed. But then, and as Jim said, 14 years later when the issue did come up, I didn't realize that they were not allowed in Community Village. Jim pointed it out. We told people that the city doesn't allow them, but that we'll work with them to see if we can get that changed, which brings us to why we're here tonight. And then specifically with that as well, we're going to have a handful of models and architecture that's allowed, and so that the HOA will tightly control that, just to make sure there's consistency within the neighborhood.
I have a few thoughts that I'd like to share, if that's okay. So I'm a resident of Meads Crossing, and I'm in the townhouses specifically. When I was looking at the single families this weekend, there were a lot of very nice fences that are adhering to the HOA guidelines, um, white vinyl. And for the most part, there were 2 models, and they look very nice. But even that choice to be able to erect the fences that are adhering to rather strict guidelines, when people take into account the property line, there were a handful of places in which maybe there's 1.5 feet between. And so the issue is now there's grass and weeds that are about 2.5 feet between. And I know that a village community is not all about aesthetics, but that's not very appealing or attractive as a resident. And then when I'm pondering up to 120 square feet for these outbuildings, the lots are not large. So looking at a yard possibly being 20% covered by an outbuilding, some wanting, some not, different models, here they are, some don't, some have. The generic definition of a village community, there are many aspects to take into account. One would be the rhythm. And I know over time, granted, we're looking 12 years back, 2009-ish, 2010-ish, when those first came onto the scene. But at one point, the townhomes, where I am, they were going to be closer to the road, possibly an alley behind. So the automobiles and everything that might take away from that village feel would be behind. But that changed. And so, I mean, I'm thankful I can park my car in the driveway in front. But technically speaking, the driveways were supposed to be shorter so that I would have my car hanging out over the sidewalk, which we know is not permitted. In cities, you can get tickets, citations for impeding the walkway. And so that village feel, or at least, once again, the aesthetics of the unified front, the architecture is beautiful in Meads Crossing, I think, personally. But with all of the differences in automobiles, the longer driveways, all the changes, some of that, I guess, desired aesthetic feel and vibe that makes that community village has already been subtracted. And so I'm very hesitant to now fill in odds and ends of different buildings here and there and everywhere, or maybe once again just 2 people, and where were they going to place it? Because I believe it'd still be a 5-foot setback, and so that's going to eliminate a good amount of border around a backyard that's already on the small side. And so then those buildings start to migrate towards the a third in. Once again, my concern is just that aesthetics, and at some point, I think we're going to lose that aesthetic want of what is a village community.
Is there anything that dictates the aesthetics of the sheds?
We are developing a standard. So, and we had the conversation with the city about this, that you all don't really want to be the aesthetic police. And it's incumbent on us, and it's in our best interest for us to do that. So we need to be, placement of the sheds is going to be tricky. And it does require some, scrutiny. So back to where you started with the gap between fences, if somebody wants to build a fence on their property line and they're first, then the neighbor has to get their written permission to connect into their fence. And if they don't, then it creates that gap. And some neighbors don't want it. They don't want to share a fence.
Right.
So in those instances, it's back to us, as us being the HOA, and we're doing bi-monthly inspections to pick up on that. I'd love to get the location, because we will, having high weeds is not acceptable. So.
And for me, when I signed on in the townhome, it was up front. I was given everything in advance. I knew in advance, I can't have a fence. Okay, I'm gonna buy this house knowing I can't have a fence. I can't have a shed. Okay, that's a part of me doing business with y'all. I'm not gonna have a shed. So that was a part of the whole process. So then to go back and say,
Well,
I really
that's-
want a shed.
I mean,
Well,
that's,
and
I have a single car garage, and then all the new homes have double car garages. So there is space to store things.
Yeah, well, and
that's my problem with it, is that, I mean, again, it wasn't allowed to begin with, and if you're going to allow a certain section of the people to have these sheds, I can see where townhouses are definitely gonna be irked that they're not allowed to have the same options, even though they signed into the same agreement of not having sheds.
Right, well, but it is, as Mr. Hand said, it's very clear that they're not allowed for townhouses. In our HOA documents do allow them.
Was it not
For singles.
clear for the regular single dwelling houses that they can't have sheds either?
No, I mean, our HOA docs say
Allowed.
that they are allowed because they're responsible for their own maintenance, their own mowing. So, they're the ones that have to spend the additional time to trim around it. So.
Could I hear some other opinions from the commission? Ollie, Brian, Jim? Anything to add?
I mean, I just personally don't think this is future-proof and thought out as much as it should. As he was talking about earlier, the aesthetics of the sheds should probably be determined before this is brought up. I mean, normally for instance, when I did contract for the government, one of the first things that would have been found out was what are the aesthetics going to be before something like this would even be brought up. Another part of it is, again, I don't know how I feel about making the exception for the single dwellings and not the exception for townhouses, as we're probably going to eventually see that coming back up here. And sadly, I'll have to say nay when we do come to the vote, but, it'll be eventually up to my other colleagues here, so.
Okay. Any other comments? So Jim or Jay? This is actually a two-part. To put it down into one motion for the item, of yay for the sheds or not. What are you specifically asking us
Well,
for?
You need to deal with these separately, okay? The first one is
yeah.
the DARA, and the second is the zoning ordinance, okay? They're somewhat related, but not 100%, right? So the DARA, the motion is the DARA change consistent with the master plan, the comprehensive plan of the town? That is it.
Well,
And a
hey,
yes would be it is, and a no is that it's not.
Well, there's no way I couldn't find any place in the master plan that would show a negative against this. So if the whole thing is related to the master plan, I guess it's really,
Right. So, because your role in the DARA process under state law is the change that's being considered in this agreement by the city council consistent with the master plan? That's yes or no. And as Mr. Weeprick pointed out, that's a residential area. It's zoned for residential. Residential area has sheds generally, so this wouldn't be inconsistent with the master plan. That's
Shouldn't-
issue one.
right.
Should it not be future-proof, though? I guess
Well,
that's my question, because again, I personally don't feel that it's.
This issue is future-proofed because it is only dealing with the DARA, which is a contract that the city can or cannot enter into. The second issue is one where there's a little bit more discretion, because the second issue would not be anything with the master plan. You're giving a recommendation on the zoning change to the council. And so you can say, we recommend it because we like it, we don't recommend it, or we recommend that you look at other implications of how this may affect into the future type of thing. Because your latitude as a zoning board is much wider for zoning type of referrals. Very narrow for the first one.
So from a logic perspective, from my point of view, it seems like the first is just by default a yes. But then,
Yeah.
as you were saying, we could not recommend.
Right.
And then that information would go to the council to discuss further.
Right. I mean, we have amended the DARA for this project numerous times. And when it comes to you, it's great to get the public input and get critical thinking in it. But the answer is yes, it's usually always consistent with the master plan, because the master plan just says it's residential.
Right.
But if they wanted to open a 7-Eleven on the corner and they wanted to change the DARA for that, that wouldn't be consistent with the master plan. So yes, it seems perfunctory, but it's almost like the two issues could be reversed if we could have talked about them differently, but we don't. That the one authorizes it and the second one executes it. The execution is fine, it's the authorization that is the one you can have some discussion and possible thoughts on. My thought.
No, I mean,
Okay,
that
so-
makes sense.
All right, so at this point, I think I'd like to get a motion on the floor that it does comply with and consistency with the 2010 master plan. So if somebody can put that in the form of a motion. Brad?
I move that we approve the plan with the DAR, with the master plan, that
Second.
That it is consistent with the master
consistent
plan.
with master plan.
Is there a second to that?
Second.
Okay, second. Okay, further discussion? Is there any comments from any call? Well, I guess there isn't any call-ins, nobody's
No
going to know
calls
about it.
tonight. Yep. This is it.
So, is there any more comments before we call for the vote? Okay, all those in favor of the motion, confirming that this is consistent with the master plan, signify by raising your hand. 1, 2, 3, 4, 5, 6. Okay, it's unanimous. Either Jim or Jay lead us into the next section
Sure.
so we can have
I'll
more
let Jim
discussion
handle
on
the
it.
zoning.
Okay. So really, it's, let me get the right one in front of me. So the only change is in section 20535, which is the section that talks about the prohibited buildings, structures, special home occupations, above-ground swimming pools, individual storage sheds, and other similar outbuildings, that we are adding the text unless otherwise specified in a development rights and responsibilities agreement adopted and applying to the applicable parcel. So again, this enables a developer who has a development rights and responsibilities agreement to request relief from this section for their particular project. So it's essentially enabling language that gives an option for these things that otherwise would be prohibited in a community village. So we're adding that one sentence to the code.
Okay, could we go over again why the town think that this is a favorable thing to do?
I think it's a recognition of just the current situation that we have folks who have moved into Meads Crossing and were either informed by the realtor or the sales agent that sheds were allowed, or saw in their HOA docs that sheds were allowed. And had we identified the issue before single-family homes were on the market, we might not be making this request. But again, just with the, I guess, the delay between the original approval and the original comment and the time that homes were actually on the ground out there, on the builder developer side, it just wasn't spoken to, and the assumption was made that they could have the sheds. So once we had people living there who thought they could have sheds, and now the city's telling them they can't have sheds, they're obviously not happy about that. And this was seen as being the reasonable correction, was to, allow them to have something to meet a need that they were expecting to be able to do when they bought the properties, but not make it too permissive. So one of the things that I do like about this is, while initially, the assumption was we weren't going to have to mess with any shed zoning certificates for this whole project, is the sheds are going to be limited to a size that at least doesn't take a Carroll County building permit. So we won't have to be dealing with Carroll County building permits for any of these, because they'll be under 150 square feet of floor area. So that's certainly one positive, that it's not like another layer of work for the zoning administrator that was unanticipated. But again, it is only 300 some houses. It's not like we've got, thousands to deal with. So it's really a response to where we are.
And if you look at it, this is an odd situation. The city, if you can think about it, the city is not allowing something that the HOA is, and we trump them, okay?
Yeah.
And it's usually the other way around for like almost everything. Like in the city, you can park certain things in your driveway, you can do things. But the HOA could say, even though it's allowed in the city, it's not allowed here. You agreed to it when you got here. So there's more specifics. And I can't think of anything, like fences would be an example. We allow fences, but an HOA can say, it doesn't matter what the city said, we're going to make you do X, Y, and Z. But I can't think of anything off the top of my head where it's the other way around, where the HOA allows it and we don't. And so the feedback has been from the residents, we want this fixed. And I believe someone, and I don't remember who, somebody went to an HOA meeting. Isn't that true? Maybe the mayor did, or you did?
I attended.
You did. And that was brought up, that we were told we could have sheds when we came here, and now we found out the city's not letting us have sheds. So that's the story.
Well, I understand, and I support the idea of a residence having a shed or storage area. I guess my concern is that I built a nice-looking shed to match my house, the roof, and the siding and all that. But then my neighbor goes down Lowe's and gets one of those Rubbermaid jobs and builds and puts up next to me. I guess I'd be more willing to support this if I knew if the standard was going to be across the board for everyone.
Okay, so.
There will be a standard across the board. We're in the process. There's actually an advisory group within of neighbors in the community that work with the HOA that are developing a standard so that it has to match the color of the siding that's all being sorted out.
We'd like to see that up
Yeah, I'd
front
like to see the
before we
standard.
go. It's kind of like our standard ordinance. Kind of like to know what the outcome's going to be before we decide that it's going to be okay to do.
Just to clarify things from the city's standpoint, from the zoning perspective, the language of the code is our, what enables us to issue a zoning certificate for a particular project. It tells us how big something can be, how far from the property line it has to be, and so on. Aesthetic concerns are typically not in the code. They're not pertaining to, distance, area, and bulk on a property. So they're really not so much zoning regulations. So the code will tell us that, a shed has to be 5 feet from the property line. The DARA will tell us that the shed can't be more than 120 square feet. That's pretty much it for the code. So it really does depend on the HOA being strong enough, with that review and that enforcement, because if somebody comes in and they get a zoning certificate, we're going to put a shed on Henry House Circle, and it gets approved, and they put something out there that's not approved by the HOA, that's not a city issue, that's an HOA issue. So it'll be up to the HOA to enforce that you didn't pick from the appropriate guidelines or, the whatever the palette might be that they can choose from. So we'll go by what's in the code and the DARA, and that's how we'll issue zoning certificates. We don't have the authority to withhold a zoning certificate because it doesn't meet an HOA criteria. If it meets the city code or some agreement that authorizes us to do something different, like a DARA, we're obligated to issue it. So that's where HOAs can really come in and control what a neighborhood looks and feels like, because they can be more restrictive. They can speak to those aesthetic issues more so than the city can.
But you're asking for our recommendation.
And I think that further even proves that this shouldn't be done until there is a HOA.
A matter of process. So both of these require a public hearing. They are not going to be on the agenda, well, the hearing will not be until September because we need lead time to advertise it. It has to be advertised a certain number of days before the actual hearing and so on. So that's not going to happen until until August for the mayor and city council meeting in August. I would hope that perhaps the work group might be able to turn the product out for review by the planning commission at your next meeting so that you can have those before you and still have time to make a recommendation one way or the other on the ordinance before the public hearing with the mayor and council.
Let me put some dates on it so you guys can see how this would work. The ordinance has to be introduced before a public hearing happens, and the council's going to introduce it next week. So the ordinance that you see will be introduced and be public at that point. Your next meeting is August 30th. And they don't have to have your input before they have the public hearing, but they always do, okay?
Okay.
Because they usually vote on it after the public hearing. They would have the public hearing on September 8th.
Okay, so there's time,
They
right.
need to have 2 weeks' notice, meaning from the time it hit the paper, and 2 weeks' notice would be 2 days after the 30th.
Okay,
So, but I'm not sure you could have your decision on the 30th and then say, we're not having it, because I think it has to be to the newspaper physically before the 31st or the 1st, whatever. And then the council would vote on it the soonest, even if the soonest they could would be the 13th of September. But they could put that off. So the trick for you all is, if you don't think you're going to be able to deliver things by the 30th for your meeting, then you should say we're putting it off, because then we wouldn't schedule the public hearing, because we wouldn't want to have the public hearing and then cancel it because it costs. I guess we could, although we've never done it, have the public hearing without the planning commission input and then have the decision in October. So that could happen. But, you know, so.
Steve,
Is that something you
you
can
guys
do?
think that's feasible?
To get you guidelines by the 30th of August, is that what?
Actually, we need it like at least
Before,
a
so it
week,
can go
a
out in
week
the
ahead of
minutes.
that.
Like the 23rd.
Agenda.
I think they're asking is if you could have, I'll call them the design criteria guidelines for the sheds, or maybe the samples, or maybe. So that would be like the 23rd of September, of August. Of August, like something so that they can go out, so they can look at it before their meeting. If you think you can do that, then everything works.
Well, at this point, let me get the consensus of the commission, because I don't want to put this on the floor as a motion
Right, so
And-
you got.
and then have it fail.
Let everybody talk about it, right?
That's right. So what's the consensus of the commission? And I'll go around. Jim?
I'm in favor of it.
Okay.
I'm not in favor of doing it next month.
I'm in favor.
Next month, okay.
I got a follow-up question. I'm feeling especially ignorant, so my sincere apologies to Jim and Jay. So this second item, we're merely seeking to approve the edit to the code. And we're not specifically addressing the DARA right now because that hasn't been established. So we're merely just looking at amending the code, so to speak.
And I would say that technically, the DARA can't be enacted until the code is changed.
Okay.
Right, so that's how you bootstrap
Sure.
back to the DARA.
And it's simple,
Right.
yeah.
Yeah, so I would support
Support
the
on the
amending as it's written.
Okay.
I,
Excuse me?
I don't support it.
So you don't support it, period, or holding
Just-
for another month
I mean,
to get the,
I'd say another month to see the actual, what they come back with as far as,
okay.
you know, that's looking.
And-
It's
and-
my
and
understanding
another-
that what they
another-
come back with is separate, though, from what we're looking at with the rewording of the code. Because
Just to make sure,
this is
right.
the code rewording.
Just to make sure everybody's on the same page here. What Meads Crossing is going to come back with is going to apply specifically to Meads Crossing and what's in their DARA. So what Meads does is unique to Meads Crossing. You know, what is in the code is just going to enable some future developer, which will include Meads, because that needs to be enacted first. And if that's enacted, then Meads can come back with, then the council can entertain this change to the DARA. We certainly can offer commentary to the mayor and council on the merits of the designs that are put before you for the Meads crossing sheds. But the zoning code is just going to enable a DARA to allow the sheds or those other things that are currently prohibited in a community village. So the DARA is what gets specific with the HOA guidelines and things. That's linked to the HOA guidelines and the designs that will come back.
So you still stand by what you said?
Yes,
Okay.
and I'm willing to make the motion to amend with the given wording to the code. But I'll hold off.
Well, so I haven't asked the county for any comments.
I can't
It's-
make a
yeah.
comment.
Okay, that's fine. I did, you're
Yep,
fine.
yep, yeah.
So it looks like it's 5-1 in consensus of moving forward. And then represent this next month with the developers.
So
Yeah, okay,
how
thanks.
does this
Yeah,
sound?
give me some more
Consensus was to defer making a recommendation on the zoning text amendments.
I don't, because that, I don't think that was
Or-
Mr. Hand. I thought you were saying I'm good with it today.
Yeah, I'm good with it.
Oh, I'm good for deferring till
Deferring.
August.
Because I mean,
But
we're
you were
just
good
talking
with
about the code.
doing it.
Yeah, we're just talking about,
Talking about two different
The
things,
code,
at least
yes.
from the audience.
I was trying to get the consensus of holding off on making this vote,
we're holding off on making the vote about the wording to the amendment?
the ordinance.
Because the ordinance is separate from what they're bringing in terms of sheds. This is merely the
I
code.
don't see that.
Of it is if, okay.
I mean, in
If you wanted to derail sheds at Meads Crossing,
That's right, that's
okay,
the theory.
you could make a negative recommendation. You could recommend against passing the ordinance. If the ordinance doesn't pass, they can't adopt the DARA amendments. So that's kind of the, for lack of a better term, the backdoor approach to stopping killing sheds.
And I mean, that's
if
our,
you don't want
that's
sheds.
our leverage as the city, is that without this put in, like, if we give this to them, we essentially don't have any leverage over what we see from their designs or anything like that, which I'm not entirely sure it
But-
matters, but.
Don't we, the ordinance gets changed, then we have to come back in and request that sheds be allowed.
Right, they're two separate things is
Yeah.
my
And
understanding.
there's really three different things going on.
Yes.
Master plan,
And, well,
did that.
no, we're, that's clear.
yep, and then the ordinance that would enable us to change the DARA. So we're looking at the first two.
And there's really only two, really. Like, if the ordinance passes, okay, and the DARA passes, we're done.
Yeah.
Yeah.
You get to do it.
The DARA
That's what I'm saying. This should
The
be-
ordinance has to pass in order to allow what the DARA is doing. And what Mr. Miller is saying is that, and I mean, I get it, like, I've talked the legal side, but he explained the politics or the practical is if you only have a certain amount of tools in your toolbox, if you want to see a certain product from them, even though it's not A plus B equals C, it's not linear, it's like, well, I'm not doing this until I see this. That's the point.
And that's what the consensus was.
But what I understood when I was taking my notes is Mr. Hand was okay with just approving it tonight. And the others are maybe okay with waiting to see what they're going to do. But we're confused, I guess I was confused about.
No, it was a little confusing. I mean,
Isn't there a third strike? Because there's the amendment to allow it, and then we have to actually come in and amend the DARA.
Well, that was the first
Yeah,
thing,
that was
is
the
the
first
actual
thing.
DARA is part of it. Item number one, yep.
Yeah.
We were trying to do this as companion items because they were related.
I mean, they're similar, but.
Yeah, they are
So are
linked,
we okay with
right?
where
You
we're
can't
at
have
now?
one, you can't have the DARA without the code amendment.
I still show the count as
4-1, 4-2.
4-1, depending
whatever,
on-
right.
what Mr. Hand is here.
Is this for deferring or
Deferring this
for
to,
deferring? Okay, to August.
the consensus was to confer this to next month's meeting to give the developer an opportunity to bring back a product for us.
Nah, I think that's the best interest of the city personally.
So let's see again.
That's what we're doing.
1, 2, 3. Jim? 4, 5. 5 to 1. So carried. That's the consensus.
Jim will get you the exact date that you need it to get to Daryl. Right now, we're shooting for the 23rd. Right. 7 days, I guess that's, right, right.
We'll make it work.
In theory, that gives us a month.
Roughly.
Yeah.
Okay, so that takes care of the ordinance and the agreement for review, right?
Yes, sir.
For this month.
Yes.
Okay, so let's move on to your report. Which we covered most of that, I believe.
Okay, right. We took care of the big paragraph, right? So, so in addition to what we've already covered this evening, just some updates. Meadowbrook Section 7 reviews are ongoing. You know, we do have a couple approvals in hand already, but there's a number that are still pending. So if things play out well, we could be back before you next month seeking approval for the preliminary plan for Meadowbrook Section 7. And again, that's just the 4-lot subdivision right on Keenan Street between the railroad tracks and the first existing single-family house there in Meadowbrook. Little update on FP Duffy. We now have seen the preliminary plan. It came in the day after the packets went out. So, but of course not in time to be able to post the property and do the appropriate notifications. So they will be on for next month for presenting their preliminary plan, and that plan will be in your packets next month. They have made some changes from the concept. The building's going to be a bit bigger than originally planned, and the pavement is also growing because they realized that they were making it a bit tight for some of the truck turning movements that are, you know, expected to happen there. So it's still going to be basically the same layout, but just enlarged somewhat to facilitate better truck movement on the site. And also turned out that the footprint of the proposed building was not going to be adequate to house the piece of machinery that is driving this whole expansion project. But again, that'll be before you for next month. The Storage Today site, they're still taking baby steps on the stormwater management plan. Our consultant engineer was on vacation the past week, and the developer's engineer wanted to consult with him on the approach for stormwater management. So that's kind of pushed things back a little bit. And that concept plan was actually many years old, and not that we require stormwater approval or stormwater management to be completely fleshed out at the concept stage, but it looks like stormwater is going to be a much larger component of the plan than that concept anticipated. So they're going to be chipping away at that. Hopefully we'll see a preliminary plan next month, but I'm not sure at this point if, since they're still waiting to make sure their direction on stormwater is something our engineer will support, they may have more than a month's worth of work to do, so it might not be back to us in August. We've talked about the Sewell Farm, the Christmas tree farm on Harney Road, off and on for many, many, many months. And they are going to be on the Mayor and Council's agenda for next month's workshop. So that's, and backing up a step, we had talked a little bit about this previously, but we've gone from there being essentially a concept plan and a number of units and an expectation of reservation of water and sewer capacity to really a one-step-at-a-time approach. So we're just looking at the annexation agreement. We may talk about some very broad numbers in there. Nothing is final yet, but it's going to be before the mayor and council in August. But we've pulled back from trying to get like the whole picture of what it's going to look like when all is said and done. We have realized that, you know, we don't have all the players around the table that can really commit to that final product at this point. So there's no point trying to lock in something with people who really aren't the ones who are going to deliver it. But at any rate, that is moving forward for the Sewell Farm. Also, at the Mayor and Council workshop, we expect to have a presentation from Wilson Bounds, who owns the property at 3212 Harney Road, which is essentially the smaller farm between the Sewell Farm and West Baltimore Street that also fronts on Harney Road. That's a 33-acre piece. That's going to be a little bit more complicated because there are some properties very close to that that potentially could create an enclave issue depending upon how the annexation boundary would be drawn. So that one's going to take some additional work to craft that boundary line or to work with additional property owners to bring them into the city at the same time. But at any rate, there's going to be a presentation at the workshop for that property just to gauge interest from the mayor and council as to whether they want to proceed with discussions on annexation. And while that will not happen at the same time as the Sewell annexation, knowledge that that property is coming in shortly or is going to come in may drive some design choices with the Sewell Farm. For example, we talked about there being a possible access point onto 140. Well, the Sewell Farm doesn't abut 140, but the Bounds property does. So if we know that one's coming in as well, we may lobby for that connection, you know, as part of, or for the Sewell plan to be laid out to facilitate that future connection. And again, it's not going to be on the same timeline, but it's something to be aware of as we review. Once the Sewell property does come in and we have a concept plan, just knowing, you know, what's happening with the adjacent property can help inform decisions from the planning perspective.
This 33 acres you're talking about, is that what we were talking about last month as the Horner property?
Formerly the
So it's
Harner
one of the
property.
same?
Yeah.
Okay.
Yes. Yep. So, so that's about it for me. Just you know, usually I include in my report how, you know, how many new homes we've done. You know, 11 so far this month. So the pace is still continuing pretty strong. This month we had 6 in Meads Crossing and 5 in Meadowbrook. So kind of seems like we still can't. The builders can't put them up quick enough. So. And that's about it. And I know I kind of sort of blended the two things. I gave you some updates on projects sort of embedded there, but if anybody has questions about any of the other active projects,
Was it Meads Crossing that we were talking about maybe 2 months ago about the sidewalk issue continuing on to 194? Was that addressed?
that was Meads Crossing. The owner of that adjacent property where Meads Avenue crosses, he expressed a preference to stick with the plan and see that that sidewalk was built.
Okay. Okay, and I think that was it. Is that it, Jay, or Jim?
Just a quick little update on Taneytown Crossing. We did have a meeting in the field there. If you've been down that way, you've probably noticed that Westview Drive is pretty torn up, largely as a result of the tapping into the water and sewer, well, water primarily. And there was also a water main break immediately adjacent to the area that the contractor was working in for Taneytown Crossing. So we came to agreement as far as like how much of the road's going to be repaved and, you know, based on the spec in the plan for what has to be restored. And there were so many cuts in the road that the section basically from the driveways down to Harney Road is going to be completely overlaid. You know, sections are going to be full depth restoration of the road. And so it should look a lot nicer once they're working to close things out there. They already have people moving into or moved into several of the units. The apartment building is a little farther from completion, but the semi-detached units are just about all complete, and I think I'd say over half of them are occupied already. So that project is winding down, and as part of that, you'll see Westview Drive get repaired and overlaid. So that'll be nice for that area to get that kind of buttoned up and not the semi-off-road experience that you might have out there today. And
The corner lot on Westview and Harney Road.
we need to get a letter out to that owner.
Okay. And I remember when that project started, somebody made a comment about parking on Westview Road. Is that going to be restricted parking in the direction of the traffic, or are we allowing parking in both directions? I've just noticed a couple trips I made through there, there's vehicles during the weekend parking in the opposite direction.
Opposite from the travel
From the
direction?
traffic.
Okay, that should not be happening. That's a traffic violation because you have to cross the center line to, park in the opposite direction. So that's something that can be enforced in general.
Okay.
I do recall some discussion of there being, of the city limiting parking to one side or the other. I will have to go back and look to see if any official decision was made on that. I know there was discussion, I just don't remember the outcome.
There was a couple cars parked on the field side in the grassy area. So I didn't know, and Ollie, I thought you brought something up about parking back when we started that project.
Yeah, I did, a long time
But I
ago.
don't remember how it turned out. Okay.
We'll have to go back and check some minutes.
All right. Jay?
Jim talked to you about the importance of the Sewell annexation, and the interesting thing about the annexation law is they are not required to come here first, okay? But the way we work this is we want you all, since you're going to inherit what the town or the city council agrees to, we want you to understand all the details so that you're able to comment, even if it's at the public hearing when it happens, about what you think it is. So to the extent we can keep you updated, that's important, but you also need to make sure you stay with the city council. And Mr. Hand's job as one of the liaisons is to keep this group informed of what goes on there in case they need to be involved. So things are going to happen, I imagine, rather quickly once things start happening. And the other thing is, I thought was, I want to state the obvious, but it was not obvious to me, is that obviously we hired Mr. Hale for the city to be the planning and zoning person, but it was never really stated, at least to me, that he is going to be the zoning administrator. And so the city council is going to appoint him as zoning administrator, so that's the guy who's going to sign the zoning certificates and attend the zoning appeals board, which Mr. Hand is aware of since he was the chairman of it. And that was Mr. Weeper, but he will be the zoning decision maker for the town. So that's going to happen at the next couple meetings.
All right.
That's all I have.
Okay. Move on to the county side. It's your turn.
Yes, good night. Haven't met you in person yet, so I'm happy I finally get to be here. We are working on finalizing the comprehensive rezoning. The residential text amendments have been presented in full to the County Planning and Zoning Commission, and there was a work session on July 7th to work out the commission edits they have to the text, and so I think the next meeting, August 4th, they will be finalizing the residential rezoning amendments. And then as for the water and sewer, the spring 2001 amendment has been approved by MDE and will be posted on the website when it has been received. And the fall amendment applications can be submitted starting August 2nd, and the deadline for that is September 13th. I've sent Jim the applications should anyone need them. And for the transportation master plan, we have reviewed all of the survey results, and we will be presenting them to the County Planning and Zoning Commission on August 4th, and hoping to have further municipality involvement going forward after that.
Okay. All right. Thank you very much. Okay, other business. Chris, you have anything? No. Lee? Jim? Okay, looks like the next meeting is August the 30th. Let's hope that suits everyone. Okay, not hearing anything else? Anything from the floor? Any comments or anything? All right, I'll entertain a motion for adjournment. Second? Second, all in favor, signify by saying aye.
Aye.
Opposed, likewise. Carried. Thank you, folks.